The Scottish Government's controversial hate crime bill will be debated and voted on by MSPs later. It introduces a new offence of stirring up hatred on the grounds of religion, sexuality, age, disability and transgender identity. Now, when it was first introduced last year, legal experts and religious leaders criticised the bill for its lack of clarity and its potential threat to free speech. Since then, the Scottish Government has raised the threshold for prosecution and is to introduce new freedom of expression clauses. But there are still issues within the bill which are dividing opinion. Let's speak now to Becky Kaufman, who's the Justice Policy Officer at the Equality Network, and to Jamie Gillies from the Free to Disagree campaign. Morning to both of you.
Good morning.
Becky, if I can come to you first, are you broadly supportive of what's in the bill?
Yes, we broadly support the bill. It's a very important consolidation and improvement of a range of hate crime legislation that has been scattered all over the Scottish books for a number of years. And it's the culmination of 4 years' worth of work of trying to consolidate this. So, yes, we feel that while no piece of legislation is perfect, that this is a vast improvement over what exists right now.
Who do you think is going to feel safer as a result of it?
A lot of that depends on how this afternoon goes. I believe that it's quite important for people with the characteristics of disability, sexual orientation, transgender identity, and religion that they've now got the same protections that race has had for the last 35 years against the stirring up of hatred.
And there have been issues with free speech. There are those who are concerned about that. What would you say to them?
Well, essentially, I believe that the original concerns about freedom of speech were well-founded, but I think the amendments at stage 2 have now very clearly set the threshold in the bill that in order to be a criminal act, something has to be either threatening or abusive and be able to be proven beyond a reasonable doubt in a court of law using a standard of a reasonable person to be intended to stir up hatred. We know in practice from the religious stirring up hatred clause that clause very rarely is applied, but when it's applied, it's really important.
And Jamie Gillies, you're from the Freedom to Disagree campaign. Do you feel that the introductions to the bill have do they give you some now safety, and have you concluded that you are protected? Freedom of speech is protected.
Well, I certainly agree that there have been very important changes, and the bill has moved a long way since when it was introduced. So the requirement for intent that satisfied a lot of concerns. And, there's been some clarification about the key terms in the bill, but we still think there are problems with the government's free speech clause itself, because we don't think it puts beyond doubt that speech which is merely insulting or controversial will not be caught by the offence, or at the very least be subject to reporting.
In what way? What are you worried about?
Well, there's a difference in the free speech clause. So for most of the characteristics mentioned, it allows discussion and criticism. And obviously, discussion and criticism, that's quite an academic sounding explanation of free speech. And free speech includes more than that. Free speech does include the provocative and the offensive. And as long as somebody isn't inciting violence or saying or being abusive, then free speech is something they should be afforded, even if it is insulting. And the other concern we have with legislation is on the issue of a dwelling provision. So in public order laws south of the border, they have something called a dwelling defence, which means that the offences will not apply to private conversations in the home, which are not overheard by anybody outside the home. And that's something which was recommended by Lord Brackadale QC, who is the retired High Court judge who led a review of Scotland's hate crime laws and gave that to the Scottish Government before they published this legislation. So if Lord Brackadale felt that it was something that's necessary and something that has not inhibited the practice of the laws south of the border, we think that should be that should be included in the bill. But unfortunately, the Scottish Government
realistically, though, is anybody going to be prosecuted for something that they say around their own dinner table?
Well, the concern really isn't to do with the number of prosecutions. I think Becky would agree that probably there won't be a great number of prosecutions, because if you look at the stirring up offences south of the border, that's the case there. The issue really is to do with reporting, and there is a capacity for these offences to be weaponised by people who merely don't like what other people are saying and want to shut them down. So it's going to be problematic for people themselves if they're going to be investigated, even if no prosecution occurs. And it's going to be a problem for the police as well. If the police are required to really police private disputes and arguments and get dragged into areas which they haven't hitherto been dragged into, that's something that's going to be a frustration for officers, and which officers themselves have sort of cautioned about during the process of scrutiny.
Let's hear what Becky thinks about that. Becky, there are concerns, I suppose, from some people that they're worried that just by holding some views and discussing those views with others who are like-minded, they might find themselves in contravention of this bill.
But they're not. It's been widely agreed by all legal experts who have given evidence at stage 2 and beyond that the new thresholds clearly make it has to be threatening and abusive, and has to be able to be proven, but using a reasonable person test, to be intended to stir up hatred. I think that Jamie will probably be aware that the Faculty of Advocates in England have actually included a criticism of the dwelling defense in their recent submission on revision of the hate crime law down there, primarily because, as it's framed in England, there's a massive loophole in the dwelling defense that would allow somebody to hold a meeting of the hate group in their lounge and call it in their dwelling and be exempt from the law. So actually, to characterize that the dwelling defense is uncontroversial and unchallenged down south is an inaccurate depiction of the fact.
Can I ask about an example which is a topic of debate at the moment? Say, for instance, a group of women get together in somebody's house when they're allowed to, because after social distancing, etc. But if they do, to discuss the Gender Recognition Act, the fact that they see themselves as women first and foremost and they need protected, what happens then if somebody reports that group or attacks that group and describes them as radical feminists? Who's at fault here? Who is criminalised here, if there is an argument about this?
Nobody is criminalized. Nobody is criminalized. There's nothing in this law that would criminalize it. If somebody people call the police all the time to complain about things that aren't crime, and the police spend a fair amount of time saying, I'm sorry that disturbs you, but that's not a crime. That's what would happen in this situation.
But if it's too difficult to prosecute, what's the point in the bill in the first place then? Who's protected in that situation, Becky?
Well, first of all, anybody having a discussion in their own home, if they're not actively stirring up hatred against another group, they're perfectly safe. They're protected by existing freedom of expression protections in the European Convention on Human Rights and in UK and Scots law.
Becky, can I just bring Jamie in just very quickly before the news?
Well, this is the very problem with this proposal, because in that scenario you describe, all that we would be required to trigger an investigation into, a stirring up hatred investigation would be that somebody considered something said in that home to be abusive. And we know that people who make statements, for example, about biological sex, that is deemed abusive. Women are accused of being abusive and transphobic for saying all sorts of things which to most people would not be offensive. So the problem is these things are going to be reported. The police are going to have to follow up, and it's really uncertain what is going to happen. And existing legislation already.
Jamie and Becky, thank you both so much for joining us this morning. We're going to have to leave it there. Becky Kaufman, Justice Policy Officer at the Equality Network, and Jamie Gillies from Free to Disagree campaign.